Hello, welcome to a new series exploring aspects of the development and application of law and order in medieval England. As King of Wessex in the late 9th century, Alfred the Great had acted to engender a sense of English unity in his fight against Danish incursions, but there is no recognisable England in the national or political sense before the early 10th century, when Aethelstan, Alfred's grandson and king of the Anglo-Saxon kingdoms of Mercia, Wessex and East Anglia, annexed Northumbria to be recognised as the first king of all England. But all societies need rules governing behaviour, and the laws of Aina, ruler of Wessex, composed in 693 or 694, do refer to the English, and Bede wrote of the English people around 731. So for context, I'm going to start with some background. Most of what we know about law in Celtic society comes from Irish sources, first written down in the 7th century from oral traditions passed through the generations from the days of the Druids. Later Welsh sources confirm similar laws applied elsewhere in Britain. Known as Brehon law, after the peripatetic arbitrators, the Brehons who pronounced judgment, it covered social etiquette and the obligations owed by an individual to the tribe and to others. Every adult had what we might call an honour price. The literal translation from Gaelic is the price of one's face, a valuable possession based partly on status and property, but also something earned by merit through one's actions and behaviour. The system was based on compensation, and one's honour price was taken into account when assessing reparation and the credibility of one's testimony. Damage or theft of property usually required compensation from the guilty party of twice the value of the goods. Failure to pay invited vengeance. Under Roman occupation, Roman legislation, based on principles outlined in a written code known as the 12 Tables, applied, especially to the Roman citizens of Britannia. Celtic laws are highly likely to have continued to operate to some extent among the native population. The 12 Tables, a major influence on later law codes, developed over centuries and included court procedure, dealing with debt, property disputes and the legal rights of women. The level of gender equality enjoyed by women in Celtic society shocked the Romans. Aethelberht, King of Kent, issued a law code around 602 or 603, not long after the arrival of the Augustinian mission sent by Pope Gregory in 597 to convert the Anglo-Saxons to Christianity, an event which may have been a trigger. Although the laws are not particularly Christian, they do place greater value on the oath of a Christian than that of a pagan. Aethelberht's laws are among the earliest written Anglo-Saxon documents and the earliest surviving law code, Augustine having brought literacy as well as Christianity. Bede, in his Ecclesiastical History of the English People, completed around 731, says the laws were composed in the Roman manner. I suspect he was simply referring to the fact that they were a written code rather than to their content, which only has overtones of Roman law. The Salic law, commissioned by King Clovis, first king of the Franks around 500, may have been an influence on Aethelberht's laws. Compensation for criminal damage based on social status underpinned Anglo-Saxon justice. Not quite the Mosaic eye for an eye, more the price of an eye for an eye, as a way to try and avoid an ongoing blood feud. Aethelberht's laws provided for double compensation for any evil deed committed if the king is drinking in a man's home, an insight into the practice of a ruler travelling around his kingdom, enjoying the hospitality of his subjects while being seen, reinforcing his authority and dispensing justice. Ina, long-serving King of Wessex, had an extensive and detailed code of laws drawn up early in his reign, which began in 688. They tell us much about social structure. Anglo-Saxon society was stratified and hierarchical. status was important. There were some fine gradations for specific positions and roles, but to generalise, at the top was the king, followed by ealdormen or earls, and below them the thanes, a military elite and local lords making up the bulk of the aristocracy. Below the nobles were the free peasantry, churls at the top, peasant farmers and craftsmen, yebeurs, who would rent a small amount of land, and then the bottom rung of free, the cot settler, who typically will have use of a small plot of land but need to do substantial work elsewhere in order to support a family. At the bottom of the pile came theos or slaves. Slaves were the property of their masters and had severely limited legal protection, but each of the other classes in society, including priests and merchants, had a weregild or blood price, on which any compensation for a crime committed against them and the value of their word on oath was based. Anglo-Saxons were worth twice as much as Britons of the same social class, suggesting little integration in this period. Recourse to law for redress is emphasised. Anyone taking the law into their own hands before seeking justice in court has to make good any loss suffered as a result at double the value and pay a fine to the crown. Einer's laws are informative about obligations based on land holding. Fines, for example, were specified for neglecting to do compulsory military service at 120 shillings for a thane and 30 shillings for a churl. They also tell us about land use. Regulations concerning straying cattle indicate open field agriculture was practised across most of Wessex at the time. There are also laws regarding support for widows with children. Good governance is the object of these laws, sometimes referred to as dooms, in the sense of final judgments. The king asserting control with the aim of ensuring law and order, a cohesive society, and the avoidance of blood feuds that might last for generations. At the end of the 9th century, towards the end of his reign, Alfred the Great used the law codes of Aethelberht, Einar, and Offa, 8th century king of Mercia, as the basis for his own Doom book. In the prologue, Alfred refers to himself as the king of the West-Saxons, but the reference to the laws of Mercia and of Kent imply an intention they would be more widely applied. He tells us he was keen to build on custom rather than devise new laws, and that he has chosen from these earlier codes those he considers most just, rejecting some and amending others. Alfred's code is grouped into sections dealing with specific subject areas such as property and families, the rights of and responsibilities of tenants and landlords, and crime. Fines for allowing prisoners to escape from custody indicate that at least some royal manors contain jails. Resolution through compensation remains integral. Next time, the administration of justice at local level through hundred and shire courts. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.